Scott Sherman has been poring over these Supreme Court documents. Some fascinating stuff going on here. A day we'll be talking about for years to come. Scott Sherman, let's first start with the Defense of Marriage Act,
yes,
which came out about 40 minutes ago. What did that say?
Supreme Court said, 5-4, written by Justice Kennedy, that the Defense of Marriage Act banning legally married gay couples from getting federal benefits, that's unconstitutional.
Okay.
And yet they did not elevate gays beyond their sort of heretofore regular classification, meaning this: they don't have special treatment, such as gender or race, creed, color, national origin, which would require the states or the federal government to have really strong reasons for infringing on those groups. They didn't elevate their status, but they said there is no rational basis. There is no reason for a state lawfully recognized gay couple from getting federal benefits.
Okay, so the state of Massachusetts allows gays to marry.
Yes.
So a federal employee in Massachusetts is married. They get federal benefits.
They should, yes.
Okay, because it's legally recognized by by a state.
Yes.
Then the federal government must then recognize that marriage as well.
Yes, and the reason for that, because we always talk about preemption, the rock, paper, scissors game where the feds can pretty much do what they want.
Right.
In these cases of domestic relations, of marriage, that is traditionally a power of the state. This is really a 10th Amendment states' rights decision. Marriage is a decision of the state. Federal government, if a state decides that people have the right to be married,
right,
stay out of the way.
So basically, it's a very conservative ruling in that the federal government's not going to tell a state what to do, what not to do.
You can actually say that it's a conservative ruling for those people that talk about states' rights,
okay,
that if a state to be lawfully married in that state, it's the federal government should butt out. And the reason they should butt out is they don't have any good reason for violating those people's right to get married.
Okay. If you're married in Massachusetts,
yep,
that allows gay marriage, and you move to a state like Missouri that does not allow gay marriage, what does this do for that?
You know, you would think under the full faith and credit clause of the Constitution that one state would be required to recognize the law of another state. It doesn't. The opinion does not touch on that at all. It stays in the narrow confines of the federal government. However, the arguments are going to now be made that if you're married in Massachusetts or Hawaii or Iowa or California,
right,
or the other states, that the states that don't recognize that must recognize that. So now you've got a battle sort of between these states. I don't know how that's going to shake down, but to me, if the federal government has to butt out of this issue, I think states are going to have to, abide by the other part.
I think
of the Constitution.
it's important to note that this first one, this Defense of Marriage Act, doesn't say that Missouri must allow gays to marry.
No.
It just says that states that allow people to marry get federal benefits.
Yes.
So in other words, Bill Clinton's Defense of Marriage Act is ruled unconstitutional.
Bill Clinton's
5-4.
DOMA is dead. And the reason that DOMA was even heard is unbelievable because it was such a sort of, I guess, razor-thin decision on whether or not to even hear the facts of this case or rule on them when they didn't rule on the facts of the case in the California Prop 8 case.
All right, we're going to get to the Prop 8 in a second.
Yeah.
Okay, so this is 5-4.
Yeah.
Did it come down conservative versus liberal lines?
It came down the way we talked about. It came down really on the sort of the privacy proponents versus the sort of federal government can do whatever they want proponents. It's an Ask Justice Kennedy decision. He's the one that wrote the 2003 Lawrence versus Texas case that outlawed gay sodomy laws.
In which Scalia said states can do whatever they want. And if you want to do it, change it at the ballot box, which seems to me that conservatives liberal and liberals conservative on this issue.
It's topsy-turvy, and the thing is, what we have to learn is nobody is consistent enough when it comes to the Constitution. It's all seems to be whose ox is being gored.
Okay, now let's go to California.
Yeah.
Prop 8 was passed by the voters
Yes.
banning gay marriage.
Right. And it was in 2008 because Obama was such a runaway winner in California that California had a high turnout primarily because of Prop 8, which was the anti-gay marriage voter referendum.
But Prop 8 passed banning gay marriage in California.
Yes.
That was sent to the higher courts. The
Yeah.
higher courts said, no. We can't stop gays from marrying. This Prop 8 is unconstitutional. That then went to the Supreme Court.
That's right.
And what happened?
Today, they punted. This is a real punt. We talked about this morning, you and I, about the one argument that was made in the first part of the Tuesday arguments of these cases, whether or not the private sort of proponents of Prop 8 could stand in the shoes of the California Attorney General who refused to defend Prop 8. Could a private party stand in the shoes of a federal entity and defend either a statute or a referendum? And we were like, well, I think so because of Bush v. Gore, right? They did that before. They didn't have standing. They gave them standing. And you said that was a one-time deal. You were right.
As usual.
The court in this case, again, talking 5-4, said no standing. We're not going to decide the issue that the entire country has been waiting for us to decide. This is the biggest punt in the world. And the weirdest part, the conglomeration of this group, I don't even think these people would sit at the ballpark together.
Who were the 5 who voted that the people who brought this have no standing, therefore we can't decide this because you're arguing this and it's an argument you don't have a stake in.
Right. Ready?
Ready. Go
John
ahead.
Roberts, Antonin Scalia, Ruth Bader Ginsburg, Stephen Breyer, and Elena Kagan. You talk about a mishmash of philosophy.
Clarence Thomas was on the other side.
Kennedy, Alito, Thomas, and Sonia Sotomayor voting that there should have been standing. So Scalia defected from the Bush v. Gore when he voted there was standing for George W. Bush at the time. Now he's saying there's no standing. And then the 3 other ones that said Bush did have standing, they said that, yeah, this had standing too.
Okay, but so they didn't even get to whether this is constitutional or unconstitutional because they couldn't answer this first question, which was, does this person have a right to make this argument?
No, and that's right. And Chief Justice Roberts, in his opinion, he writes for the majority, he spelled out, hey, they asked us, is this a violation of the Equal Protection Clause by singling out gays? Is this a violation of the Substantive Due Process Clause by putting more restrictions on marriage? He said these are really important questions that we cannot and do not have the authority to answer. Yet they did do almost the exact same thing in the DOMA case, which they released 15 minutes earlier.
It's almost like a parent has an argument with 2 children, right? Your brother and your sister, and they're arguing, and another cousin comes in and says, wait a minute, I'm going to fight for the sister in this case because she's getting wronged. And the parent says, I'm sorry, cousin, you're not in this fight, therefore I'm not going to rule on anything.
Yeah. Or like giving 2 kids who are twins different bedtimes and saying, because I'm your dad and because I'm your mom.
So what does this mean for Prop 8 now? So Prop 8, it refers to the lower court, which overturned Prop 8, which Prop 8, remember, banned gay marriage. The lower court said, no, you can't ban gay marriage. So since the Supreme Court didn't rule on it, not saying yes or no, saying bring us a case we can rule on, as of now, Prop 8 has been overturned, and gay marriage is legal in California?
It's legal in California. And the Ninth Circuit Federal Court of Appeals, which has jurisdiction over about 10 different states, their thing was, hey, California gave these people these rights. And just like sort of the DOMA case, you didn't have in this referendum a rational basis or a reason to take that right away. The state of California made that decision. So this doesn't even expand beyond the borders of California into Idaho and Montana and Colorado and other states in the Ninth Circuit. So it sort of reverts back to what the California Supreme Court said, which is gay marriage in California is legal, and this case has really changed nothing since that decision.
More on this through the coming weeks and months. Books will be written about what we're talking